everyone. Thank you all for coming. Again, this is the last episode of the first season of our construction law seminar series. Had very interesting experience of teaching and learning, of improving our capacity of watching and absorbing knowledge. And this is a very interesting initiative. I hope you all enjoyed. And for the final session, we have Nicholas Gould in here. He's going to introduce himself, so I'll save you from my words, and I'll leave it with him, and I hope you all enjoy it. And please bring the questions at the end.
Thanks very much. Thank you. Good evening, everybody. Good. How are you all doing? Good. Okay. So I'm Nicholas Gould. I'm a solicitor and a partner in a law firm called FIDIC Aims. We do nothing but construction engineering law, but for my sins I did start out working on building sites. I spent the first 8 years of my life on construction sites and studied to become a surveyor. I'm still a chartered surveyor, and I did spend a few years here, although I left 20 years ago. So I was a senior academic here for a few years until 20 years ago. So it's nice to be back. It's changed a bit. So what I want to do is talk to you about FIDIC and the NEC, and I'm going to do it in a slightly comparative way as best as I can. Do you all know what FIDIC is? No? Maybe? FIDIC. So FIDIC is, you know what a standard form is. Yeah, you've looked at JCT, haven't you? You know what JCT is. NEC, standard form, you've seen the NEC maybe. So FIDIC is the Swiss organisation, which is the Federation of Consulting Engineers. It's an organisation which is an umbrella body really for the whole of the world. So they have about 90 members, that's 90 country members that support them. So in this country it's the ACE, the Association of Consulting Engineers, which is the body that sits above the various engineering institutions here, ICE, structural engineers and so on. They have one umbrella body and that talks to FIDIC. And then FIDIC acts as an umbrella body for the world. And they've produced the FIDIC contract, which is the most widely used standard form in the world. So if you're thinking about JCT or NEC, the minute you pick up a FIDIC form, that's used more than any other form anywhere. So if I work in the Middle East a lot, and we pick up FIDIC contracts all the time, Africa, Latin America, over in Asia, we see them, you know, all over the world. So they're very, very widely used. So what I want to do is give you an overview of the FIDIC suite of contracts, and we'll look at the NEC. Well, I'll look at the role of the project manager under NEC and compare it to the engineer. We'll look at works information. We'll talk a bit about partnering and early contractor involvement. That is not really a FIDIC thing, that's an NEC thing. But we will look at early warnings, design, a bit of time management, you know, extensions of time and programming, a little bit about payment, and then compensation event, that's the claims. And also time bars, that's where you lose your rights to bring claims, which is something that's becoming very common. And then termination dispute resolution. So that's a bit of a quick overview of the key topics I want to look at. We'll look at some more quickly than others, and it's really to give you a flavour of what's going on with FIDIC and NEC, from my perspective, reasonably internationally. We could spend about 2 or 3 days just trying to understand FIDIC, and then another 2 or 3 days just doing NEC. So we're just going to cover some key topics. That's all you can do in this amount of time. So the FIDIC suite of contracts then, the first FIDIC contract was just the ICE contract. Do you know what I mean by that? The Institution of Civil Engineers, 4th edition, was taken by FIDIC in the 80s, and they added an additional clause which was just the choice of law clause. So if you're working in the UK, you don't need to worry about what law applies, it's going to be English law. But if you take a contract and you've got a German contractor working on a project in Ethiopia with designers from France and funding from Japan, you need to start to think about what law applies. So that's all they did, was added a choice of law. Now the law of this contract is, and you could write in whatever you want. And so that then became something called the Red Book. So the Red Book was just aptly named because it was red, but this was the traditional contract. So what do I mean by that? Design and construction was split. Traditional contract. So that you've got an employer and he's got a design team. In this case, it'd be the engineer, and then the contractor just builds to the design given to him by the employer. Yeah. So that's the red book, and we know that this is not very common anymore. So we've now got the yellow book, and the yellow book is design and build. So that's actually the one that's becoming most commonly used. As indeed, if you look around in the UK, the most widely used contract form here is the JCT design and build, isn't it? So the rest of the world is slowly following that model because it likes the single point responsibility. So the yellow book's very common. Then we've got the silver book. This is an EPC contract, turnkey contract. What do we mean by turnkey? You just turn up and use it. Common, say, for process plant or maybe a power station. If you're buying a power station, you want it just to work. You may even want the contractor to train your employees to run it, because it's no good someone saying, here's a power station, off you go. You need the team to be trained. So that is the approach to the silver book. Green book is just a short form of contract. And then there's a few others. Dredging. The gold book is a kind of an attempt at a sort of a long-term concession contract. We call them PPP in this country, but internationally they design, build and operate, meaning operating it for a period of time before you hand it back. Pink book is really quite common actually. The pink book's just a variation of the red book, but it is where you've got an international bank funding it. The banks don't like the basic standard form contract, they like a bit more strength to it, a bit more control by the owner if they're lending money. So this is used quite a bit, and I'm working on projects with the pink book a fair bit. There's a subcontract as well now, and there's a few other documents like the white book for consultants and so on. Not many amendments, just the FIDIC guide, and then one amendment in 1999 to do with enforcing disputable decisions. But tomorrow, so bearing in mind these are all 1999 documents, tomorrow the 2017 version of most of this stuff is going to be unveiled at a conference. So FIDIC here for 2 days, tomorrow and the next day, relaunching their contracts. So after many years of consultation, they're going to be relaunched. So if you look at, you'll see 2017 version, everything's going to change a bit, not too much from what we're going to talk about tonight. So anyway, that's where I'll be tomorrow. Sequence of key events. So let's just have a look at this. So if you've got a JCT contract and you let a project on a JCT contract, what tends to happen is you serve a letter of intent on the contractor and they start on site. Are you familiar with this? The theory is we go out to tender, we agree a price, we sign a contract, the contractor starts on site and they build. The reality is you go out to tender, there's discussions and negotiations about the price. You eventually agree a price with the person who's successful, you want them to start on Monday, you give them a letter of intent because no one can be bothered or has got the time to get the contract together, they start on site, and about a year or two later someone remembers that you need to get a contract and sign it. And if there's already a dispute, you have a massive argument about what terms and conditions apply, which is great because it keeps me really busy. But why people let contracts like that, I don't know, but that's the way it's done in construction. The nice thing about FIDIC is they don't quite fall into that trap, because what happens is you have tender documents that are issued, you get the tender submitted, and when you issue the letter of acceptance, which is the document that's actually in the appendix to the contract as a standard form, what it does is it says, we accept your price, start on site, and all of the terms of the tender documentation and the contract apply. So when they go onto site, you've actually got a contract with all of the terms. So that's a neat way of getting people onto site. JCT could do that, be a nice improvement actually, but they don't. The other thing is you've got a base date, you know what your base date is for changes to prices and so on, and then you have your commencement date. So once you put in your letter of acceptance a commencement date, the time for completion is already, should have been in the tender documents, 2 years or whatever it might be, which fixes your time for completion. Of course, if this is assuming there's some delay, there may be some delay before you get the issue of a taking over certificate. Under JCT, that would be practical completion certificate. And then we have the defects notification period, so that would be our maintenance period or our defects rectification period. 12 months is pretty standard, could be 6, might be 2 years on larger projects, not unusual for it to be 2 years on highways projects, for example. And then we get the performance certificate issued right the way down here, which is brings the whole contract to an end. Typically these things don't get issued, everyone forgets. Just like a final certificate under JCT, they rarely get issued, but it doesn't really matter because the mechanisms of the contract allow you to identify what date these things should take place. The NEC then, I mean I've got quite a few slides on the NEC, we'll skip through them quickly. So Martin Barnes decided that it would be a great idea to have a new contract, and he's an engineer, and what he wanted to do was draft something that was straightforward and simple. So how do you think people have drafted standard forms in the past? They've taken contracts that have been drafted, I mean some of them are very old, and then they started working on them and amending them. So the Royal Institution of British Architects 60, 70 years ago was working with the Building Employers Confederation, and they started to produce a standard form contract. It became the RIBA standard form. A bit later on a few others joined in, just offering drafting advice. They formed a committee and that became called the Joint Contracts Committee, hence JCT. And then people joined that committee and gave out their time for free, and eventually then became a public company. But other people that have drafted standard forms, FIDIC for example, where did they get it from? They took it from the Institution of Civil Engineers, didn't we? We know that already, and they added a bit more. So if you pick up a JCT contract, FIDIC contract, ICE contract, they're lengthy, there's lots of words in them, and there's lots of similar phrases or sentences. That's because they've all stolen them from each other over the years. Yeah, not in a bad way, it just makes sense. And there's lots of case law on some of these phrases, so you know what things mean. And Martin Barnes thought this was a ridiculous idea because contracts just got longer. So he wanted to throw it all away and start again, which is why the NEC is interesting. He sat down with a few people and they tried to draft a very short, simple contract. So that's why it's worth looking at, because it's quite different. He wanted to have a high degree of certainty, simple language, repeat phrases, have some core conditions. So this is the thing about NEC. You pick up the black book and that's got all the core conditions. But you can take core conditions out and make other contracts. Target cost, one with a bit of quantities. So that's sensible. It's pick and mix to make up your contract. And if you buy an NEC pack, you've got the black book, and then off of it you've got the other versions made up for you from the core contract. So the phrases are the same. Because actually if you pick up JCT contracts, edited and produced in different years, they've got different provisions. Does that make sense? So you pick up a standard JCT and you think, right, another one will have the same payment provisions. It might not. They don't, because they've been drafted over at different times. Makes no sense, but that's the way it is. Now, back then to FIDIC. Well, the idea behind FIDIC is that the engineer is king still. Who really rules the NEC? Project manager, yeah. So the idea behind FIDIC is that the engineer, because it's engineering institutes around the world, and actually FIDIC is used for major projects, infrastructure, roads, bridges, tunnels, power plants, etc., tend to have engineers designing them, not architects or others. So we've got this philosophy that the engineer does the concept design and then might do the detailed design. Which FIDIC book do we have for that? Red? The engineer does the concept design but lets the contractor finish the design. Which book's that? Yellow? Yeah, yellow. Whereas the idea behind NEC is actually that doesn't work. You're trying to get a designer to think about time and money management. Get a project manager in charge of the contract and let them take the client from inception to completion and bring the designer with them along the way. So you can see it's driven by time and money, project management principles. FIDIC is still really driven by the engineer being in charge. Latham Report, you know about the Latham Report, don't you? Yeah, you know all about that. So Latham was quite a key driver for the NEC, and also, of course, adjudication, which I know you know a bit about. So the Latham Report was quite instrumental in pushing the NEC contract, and this was because Michael Latham met Martin Barnes, and Martin Barnes said, this is the contract you've got to use, and twisted his ear and kept giving him copies. I mean, That's how life works in reality. But it was, it was a good idea, and I think the NEC is a good contract. But that's really why it was pushed, and because of that, it's been used on projects here. So railway works, lots of water projects, quite a few highways projects. I see it quite often, but it's not very often adopted for smaller projects or everyday construction. Developers don't like it. They prefer JCT. The banks don't really like it for everyday development work. They like JCT. But NEC works well on more complex projects where it's driven by a project manager that does try to remain in charge. The problem, of course, is if the project manager loses a grip on the project and the contractor doesn't really keep good records, it's really difficult to know where the contractor's gone. It's all about managing it every month. Oh yes, so John Egan, he also enjoyed the contract and thought it was good. Have a look at that report if you haven't, but the government also pushed it, so there we go. The government, the OGC, thought it was good. And if we look though at the national statistics, we still see that JCT comes out on top, but NEC has really found its way up there. As I say, look, FIDIC's down here for the UK. If this was international, then it would be the other way around, except FIDIC would be not only be up here, but the lines would be much longer because it's just used in so many countries. Yeah, I mean, EDF as well. EDF likes using it. Nuclear projects, I've worked on various nuclear projects in this country. It's been used quite a bit for nuclear projects. At the moment, that really means decommissioning or improvements. I mean, most nuclear projects here have involved slightly improving and upgrading facilities to keep them running because all the nuclear power plants are quite old here. But we'll probably see NEC used for the next phases of nuclear projects. Again, it's a good contract for complex projects, providing you really manage it really, really well. So here's the NEC's history. 1993, it was a new contract, and it already came out in a second edition in 1995. And this, I think, emphasises the difference between the old JCT people that were drafting contracts for everyone to use and amending them to keep up to date, and the new world of selling contracts to people. Because JCT likes selling people contracts now, that's why there's so many. So what they did is they called it the New Engineering Contract, and they renamed it about 18 months later to the Engineering and Construction Contract, because from a marketing perspective, it doubles your market. That was the only reason. See, if you look at the construction industry here, half of it's building industry, what you might, your everyday building work, and the other half is engineering, roads, bridges, tunnels. So if you just produce a contract that people think is in one industry, you've lost half the market. So they simply renamed it to say, look, it's good for building work as well, you can use it for everything. And it did actually start to get used, but it's not so great there. Anyway, so now it's grown to a box set with 30 documents. It costs you quite a bit if you buy it, but the key thing about it is we've still got 6 main options and we still have 9 core clauses. So you pick and mix your 9 core clauses and it gives you 6 options. I'll come back to those in a minute. There's 2 dispute resolution options, W1 and W2, and there's a whole load of secondary options. But again, we'll come back to this in a bit more detail. But then you've got these X clauses, so you can pick extra things to drop into your contract. So again, I'm going to list them for you, so we'll come back to that. There's a few other extra bits and pieces, and there's some guides, and then we get Z clauses. So Z clauses are things you write yourself. So if you pick up the railway contracts here, you've got the NEC contract, which is less than 30 pages. Then you've got the Z clauses, which are more than 30 clauses. So there's a whole load of very detailed, tricky provisions bolted in to tighten up the NEC contract and put the employer on the railway projects much more in charge of what's going on and increase the liability of the contractor. So these are the main options then, and we're going to recognise them from the other things that we do. So a price contract with an activity schedule, what's that in JCT speak? with an activity schedule, it could be. Yeah, I mean, really, it's kind of spec and drawings, really, but it could be tailworks, but it's used for specification and drawings, and you put a price to it by activity on the building, just a breakdown of the building. Then the next one is bill of quantities. And really, NEC is not very good at these two, because actually, that's where your normal everyday building work is. You've got a JCT contract that does it well. This is really where you get firmly into NEC. This is what NEC is good at. This is its key one. Target contract with an activity schedule or a bill of quants. Less likely, this is the main one. So how does this work? This works on the basis that I've got a concept designed, perhaps it's half designed, maybe it's perhaps it's a heavy sort of infrastructure project, extension to a port, for example. It's going to cost 70 million, maybe. And I want a partner, a good contractor that's used to doing heavy civil engineering work and works in marine works. And we're going to find a way to pick them based upon a management fee, uplift in terms of profit, and prices for activities of the construction operation. And then we're going to fix a target price. So we're going to fix a price at maybe 70 million, 75 million, whatever it is, based on a decent cost estimate. And then when we agree with the contractor that target price, if they can save money, we'll split the saving with them 50-50 or 40-60. I might keep 60%, they'll get 40%. If it goes the other way, then they're going to suffer the pain of paying it. So suddenly the incentive is, let's hit the target price or less. And civil engineering work is known for missing the target price by a mile and costing a lot more. So what you're doing is you're not only buying the contractor's efforts and knowledge to hit the price, you're incentivizing them. They're going to work with you, and you've got to work with them, or you both suffer. It's a great way of making both parties work together. It's partnering done properly. You can agree to partner under JCT, but whatever, if you don't do it, what happens? Here, if you don't work together, you both lose money. That's why the NEC Option C is such a good contract. I mean, there have been problems with it. One of the port projects started out with a target of 56 million and ended up 110 million. And that's because the concept was wrong and all sorts of problems. But that's unusual. It does often work well. There's your cost reimbursable contract, and there's a management contract. These are used less, but it's all there for everyone. You see, you can't say I don't use NEC because it doesn't do cost reimbursable. You can stick with NEC if you want and use it for everything, which is helpful. And then you've got a guide for everything as well. Here's your 9 core clauses. So the general clauses, we'll come back to those in a minute. Then there's provisions about main contractor's responsibility, managing time, we're going to look at that, testing and defects, payment, compensation of events, which is claims, title to the project, risk and insurance and termination. If you compare that to JCT, it's a little bit more structured in terms of starting the job and finishing the job. Makes a bit more sense, I think. Hopefully you don't end up terminating. But you can see the main things that you need are spread around here. Time, finishing the job, payment and claims. So in the middle of the contract you've got all the things that happen in the middle of a project. There's our secondary clauses. So look, first one, price adjustment for inflation. You can see why it's secondary, because you might never need it, but you've got to think about whether you want them. Multiple currencies, I've got an NEC project in Dubai at the moment which is paid in dollars and dirhams. It's got this provision for multiple currencies. They're paid in different percentages. I think it's 70-30 for some reason. You could have a bonus for early completion or sectional completion. So you can find the things you want. Even retention's an extra in NEC. It works on the basis you might not have any retention. And if you do, then you put that in. And if you have that in there, is it going to be backed up by a bond, or do you really keep the money back? Z clauses, only when necessary. Rudy Klein, anyone read Rudy Klein's from building. He's a subcontractors kind of guy. He looks after the subcontractors and always writes some comments about them, and he doesn't like the Z clauses because of course they're usually purpose written to make the contract tougher, which is the case. And then we get some public sector clauses, MOD work, Ministry of Defence work, official secrets and so on, because the NEC does get used, for example, in relation to missile sites and Ministry of Defence related projects, so you get these extra bolt-ins for that type of work. And BIM, of course, is in there as well. Okay, so the project manager then. So I've already said to you that the project manager is the main focus. They manage the contract on behalf of the employer, but it could be an individual, it could be a team. That's the interesting thing about NEC. Under FIDIC, you really are supposed to have a person who is the engineer, so you can identify who that person is. I mean, even if you do have a team under NEC, you still really need to know who the main person is. The decision maker should be an individual. But the nice thing about NEC is you could have a multidisciplinary team to help that person run the job, because you're going to need, these days, all sorts of people in the background, aren't you? The engineer needs probably a quantity surveyor, an architect, other people to help them run and manage the job. Changes to the works information. So the project manager can change the works information, which of course is JCT speak for variations, but they need to visit the site, they need to be proactive, they need to know what's going on. You can't just let the contract happen with NEC. It's very interactive. You need to know what the progress is, you need to manage change, and you need to look at compensation events and exercise judgment along the way. And we'll come back to the importance of compensation events. Whereas under FIDIC, we've got the red and yellow book with the engineer. This is the person appointed by the employer to run the job as the traditional engineer. They make decisions and they do all those things. And then in the silver book, we don't have an engineer at all. We've got an employer's representative. And in the gold book, why don't we have an engineer in those two? Yeah, well, it's because you don't need it. With red, the engineer's designing. With yellow, the contractor's designing and the engineer is checking. In the silver book, you've contracted with me to give me a power station that works. I don't need an engineer to help me with your design. If it doesn't work, it's your fault. I've got an employer's representative that might be an engineer who's going to say to me, I don't like what the contractor's doing, as in like a policeman sort of function, but they don't need to be. Because ultimately, if it doesn't work, it's the contractor's fault with the silver book and with the gold book. So that's why the emphasis is taken away. The contractor can't say, you've got an engineer, they know what they're doing, because actually I can say, I haven't, I've got a representative, they may be an engineer, but they've got no design responsibility. Their decision-making functions are very small. It's to make sure that the contractor doesn't pass back some of their risk to me through the engineer. They hold it, they keep it. Risky contracts. So there we are. There's a big list of things that the engineer can do. They can have these slides, can't they? They can get all these slides later. Yes, so you can have these slides. So, I mean, we could go through this, and it's a bit of a boring list. But basically, you can see they're running and managing the job. And I just want you to get to the point where you can see that they're running and managing the job, and they've got to deal with things like variations and change. They have to be replaced within a limited period of time if they resign or something happens to them. And that's quite a different scenario to the employer's representative. Now, one thing that you have in the Red Book, and indeed in all of the FIDIC forms that you don't have in any of the JCT, you may never have seen this before, is a determination provision. So an engineer in FIDIC might be required to make a determination. And this is a gateway between all the time and money and change issues and problems on the project and dispute resolution. So basically, if I'm the employer and I get the engineer to change lots of stuff, issue lots of variations, the contractor might want more money. So the contractor is going to put in a claim. And the way to manage that is that the contractor will put in a claim and try to persuade the engineer to value it and deal with it. And they might do that and everyone agrees it and that's the end of the matter. But if I'm the employer and I'm not happy with the figures and the contractor's not happy with the way that it's heading, then the contractor can ask the engineer to make a 3.5 determination, and that triggers this process. It means that the engineer needs to talk to the contractor and the employer about whatever it is that's happening. Probably going to be variations or value variations or delay. If he can't get an agreement, then power falls to the engineer to make a decision. So basically, he's going to decide how much should be paid or not paid, and this crystallises the dispute. So it's a bit different to what happens here, because we have a domestic adjudication here, and if there is a dispute, it goes straight to an adjudicator. Could do. So this process wouldn't work, because you just fall straight through this process and go to adjudication. But actually on an international contract where adjudication doesn't apply, or Housing Grants Act adjudication doesn't apply, this process is where you get funneled to in order to end up with a dispute. So if you don't like, as the contractor, what the engineer decides, then you go off next to the dispute resolution clause, which would be your dispute board and maybe beyond. Does that make sense? So it's quite a nice mechanism, because it means everyone can argue about figures and it's not too serious until you hit this clause. The downside is, I've got lots of projects that are 3, 4, 5 years long. They go all the way to the end. No one's sent anything to the engineer, but then they all fall out and want to have a big argument in arbitration. You can't do that until you've sent everything to the engineer. That person has made a 3.5 determination, because you don't have a dispute that you can take to arbitration until you've done this. Works information. So this is kind of speak for employers' requirements or specifications under JCT. So this is what we get under NEC. It's to specify and describe the work, state the constraints. It's in the documents or site data, it's the works information is given to the contractor, and that's what he prices, and that's what he works to. And this is the documentation that the project manager might adjust or change in order to create variations. But the thing about it is, it's kind of potentially expected to be more than a usual employer specification. NEC allows you to write it in a much more broad way or a much more detailed way. So you can really, if you're switched on, describe the project that you want and tie the contractor down. And if it's quite incomplete and you've got lack of clarity, you can end up really struggling to manage the project. But at the same time, if you set it out very carefully, then you can really control your project. And one of the nice things that JCT does is it has a hierarchy of documents. You know that, for example, a specifications is higher than the bill of quants, and that the drawings come above that. You don't quite know where you are with all of this unless the person drafting it decides to put things in particular categories. Core Clause 10. So this is where we get into partnering suddenly, which we don't really get into in FIDIC. And why is this? The NEC is a very strong project management handbook, but it's also potentially a partnering contract, but it's the toughest partnering contract you're ever going to see. So Core Clause 10 says the employer, the contractor and the project manager, all three parties, not just the two in contract, because in here really it's only the employer and contractor that are in contract, but all three, including the project manager and the supervisor. The supervisor is just someone that's supposed to be based on site recording information but doesn't make decisions. Shall act as stated in the contract and in a spirit of mutual trust and cooperation. So it looks like a partnering contract because it says we're all going to get on nicely and work together, and then the rest of the contract is very tough about who's going to do what in very limited time. And it's the only place in the contract that uses the word shall. Contracts are traditionally full of mandatory language. The contractor shall, the architect shall value. But NEC doesn't do that. It only does it here. So it basically, from a lawyer's perspective, says you must do something that we can't actually measure legally. Does that make sense? Now, because someone says to a lawyer, well, what is a spirit of mutual trust and cooperation? And they say, well, it's where you all get on, or if you don't, you don't. But you can't measure it, it's subjective. If the payment provisions of the contract say the employer will pay on the 30th of each month, I can help you with that, because if you haven't been paid on the 30th of each month, you're in breach. But it's quite hard for me to say whether someone's in breach of that. And even if I could, what have you lost? If you don't get paid on the 30th of the month, you know you haven't been paid the amount in the certificate. There we go. Late payment, work out the interest, we've got a remedy. But here, what have you lost? It's quite difficult. But it's nice to see that the contract starts out by pushing people down the road of cooperating. And actually, good NEC contracts are where these people do all work together, push things forward, try to get on, and behave in a grown-up kind of manner. It doesn't matter if you don't always get on. If you keep pushing the project forward, that's good enough, really. When you all fall out, it becomes very difficult. So this is where Humphrey Lloyd, one of the judges, he's been a judge for a long time. He's kind of retired now, but he's gone to work as an arbitrator. He's basically pointing out that it's very difficult to know what good faith means, but it certainly means that if people have said they're going to try to work with a spirit of mutual trust and cooperation, they're going to try to get on and not be difficult with each other. So he's said that, even where it's a non-binding partnering charter. Because he said, what's the point of having a non-binding charter if you aren't going to try to be more helpful with each other? It must mean something. So that's encouraging. Now, the more recent cases, we've got a case here, South Anglia Housing, and this was based on an NEC contract with the spirit of mutual trust, fairness and mutual cooperation. What happened there was that the parties fell out, and eventually there was a termination of the contract. So it got to the point where the contract was terminated, and one party tried to argue that really it shouldn't be terminated like this, that we're supposed to get on and find a way to complete the project, and you need to look at the termination provisions in a partnering kind of way. And the judge went around the houses with this and decided that if you're trying to work together, then you might be able to see how people are not helping each other and potentially in breach. But if someone decides to terminate the contract, providing they follow the notice provisions of serving the notices on time, then they terminate the contract and partnering doesn't come into it at all. You don't introduce subjective views, which is partnering, into strict time limits in a contract. If the parties have agreed they're going to pay on certain days, or they're going to issue a certificate on a certain day, or they're going to terminate in a certain way, then that stays in a very rigid format. But then we all know where we stand. It makes a lot of sense. Similar provisions applied in a Northern Ireland case as well. So is the NEC a partnering contract then? Well, kind of yes, in a non-binding way, and maybe where you've got general provisions, there it works, but overall you've got to stick to the strict words of the contract. So that's why I say the NEC is a partnering contract, but it's very tough. You've got to manage it well. But I think it's a good way to work in the industry. It's a carrot and stick approach. Let's get on together, agree a programme, and then go and do it. And if we don't go and do it, we're in breach and we know who's liable. It's a grown-up way of working. Early contractor involvement. Now this is interesting. NEC has this, but other contracts don't, although FIDIC might be introducing it. And the idea is to get the contractor to assist with carrying out the design. And then when you appoint the contractor, you fix the contractor's key personnel. So rather than simply saying, we're going to have whichever contractor it is, and then they come on and they employ a team that's not so good and they keep changing their team, you fix the team. And this is what they did at Terminal 5. So the new terminal that was finished years ago, actually now over at Heathrow, they took the NEC contract, they rewrote quite a few bits of it and they called it the handbook. But essentially what they did was they picked people to work on that job from companies rather than pick the companies. So when people went to pitch, a company went to pitch, they had to take their team, they'd probably put forward their A team to try and win it, and then they had to employ those people and they couldn't change them. It's a nice mechanism. You can see why it only works on bigger projects. You get commitment, which you wouldn't get on smaller projects. So the employer's obligations, I mean, it's pretty much the same in most contracts, to give over the site, to give uninhibited possession of the site, and try to cooperate. But under FIDIC, we have these two clauses at the bottom that are quite interesting and unusual. Sub-clause 2.4 says that if the contractor asks you in writing to provide reasonable evidence that you can fund the whole of the contract, you have to do it within 42 days. So that would be quite convenient. Doesn't happen in JCT, and in fact, when employers realise what this means is they strike it out because it's possible to terminate a contract if you don't get reasonable evidence. If the contract's $500 million and you write to the employer and say, please can you prove to me that you've got funding for $500 million, that can be quite a difficult thing to do, even if they can identify the money. You know, you're talking about someone at a very, very senior level who's able to write that letter. Yeah, if you write to the Ministry of Transport in a particular country, you know, they've got to rely on people around them and their finance department to be able to say, well, we've got these budgets and we know we can pay for that road. Then we've got employers' claims. So if the employer's got a claim against the contractor, they have to serve a notice. Do they do that under JCT, NEC? No, they just deduct the money or don't pay. But here there's an anticipation that they will have to serve a notice, and no one ever does because they forget. So this is what clause 2.4 says, and the real thing to notice about this is that if you don't get the evidence, the contractor can suspend work on 21 days notice, they're entitled to an extension of time and money, and they can recommence work whenever they get decent evidence, but they can terminate on 14 days notice if they don't. There's one reported case on this, and it relates to the construction of a hospital in Tobago. NH Contractors, a local contractor down there, were having an argument with an insurance company. And what happened here was, look at the chronology, 3rd of September, the background to this was the contractor had had enough and wanted to find a way to terminate the contract. What ways can you do this when you're in trouble, when you're not being paid, or things aren't going quite right, and you can't find another way to terminate? Try this. Ask for evidence that they've got all the money, because if they can't answer it, suspension, termination, you're out of the equation. So the project administration unit said that they had funding for additional money. Now the other context to remember here is that you've got a contract sum, it's in delay, there's variations. How much do you have to demonstrate that you can fund? The original contract sum, just the extra bit, all of it? The contractor's guess about how much all of it is, or my guess as the employer about how much it might be? You can see straight away there's a dispute about what the figure should be. They kept making requests, the contractor reduced their work. The permanent secretary at the Ministry of Health said that the estimated final costs were 286 million local dollars, and the contractor still continued to push them. They suspended work. Now there was a new permanent secretary and he was a bit more switched on. He wrote and said, the project's of high priority, the estimated value of the work is this much, not that higher figure. This is how much we think it is, not the contractor's claims. Funds are available to pay it all. Any money certified will be paid by the government, and the government is the government and it's always going to find a way to fund things. The government stands behind the project and will pay. Now the contractor wasn't very happy with this and eventually terminated the contract. Now, the arbitrator concluded that there had not been sufficient evidence and therefore the contractor was entitled to terminate the contract. And this was basically because the government, despite the assurances from the secretary, the permanent secretary, didn't provide backup documentation to show that the funding was there or the money would be paid. You kind of have to ask yourself what was it the government should have done and how difficult it would be. Now, the High Court approved the arbitrator's award. The Court of Appeal didn't. The Court of Appeal said, actually, we don't think that was right. We don't think the contractor should have terminated. And the Court of Appeal said the errors included a written assurance from the government should not have been disregarded. And if a government, if someone as high as the permanent secretary writes to you and says the government will pay, then you can take that because a court later on will look at that and say, well, you've got to pay it. And a direct mandate from the government is good evidence. And the cabinet approval, well, it's best evidence, but you don't need it because the clause just says reasonable evidence, not best evidence. Now, it went to the Privy Council, so let's just pause there for a minute so we know what's going on here. If you have an arbitration clause in a contract, then you have to arbitrate, and the decision's binding. If you want your decision enforced, you go to the local court, High Court, and get it enforced. If you don't like that arbitration decision, tough luck, because you've agreed to arbitrate. You can appeal points of law in some instances, but not points of fact. So when the High Court here said, we uphold the decision, they weren't actually looking at the facts of it. They just said the arbitrator's been appointed properly, he's made a decision, whatever. The Court of Appeal were interfering in that. So the Privy Council reminded everybody that really you do have to try to go with whatever the arbitrator said. The Privy Council is actually in London. So the Privy Council is the most supreme court for Trinidad and Tobago. I don't know if any of you realise this, but the Privy Council here still sits as the highest level of appeal court for quite a few Caribbean countries and some African countries and other places. Mauritius, for example, comes here for its appeals, and that's from just a Commonwealth past. You might say, well, why doesn't some of these countries have a final appeal court in their own country? Because it's cheaper to come here still. I know people in Mauritius, and they were looking at this and decided it's much cheaper just to come to get on a plane to London and get the people that sit in the Supreme Court here, or the House of Lords as it was, to make decisions for them is much cheaper. That's why they all keep it. And it gives them some consistency because they get a similar legal approach across a whole variety of Caribbean countries and African countries. I thought they'd just take it back for themselves and make their own decisions, but they quite like it apparently. And it's good for us because it means we get to read these decisions about something like FIDIC and see how it gets applied around the world. So anyway, they upheld the arbitrator's award partially. They said there's no error of law, but they did caution against this high watermark for reasonable evidence. So they were saying that actually they thought in reality the Court of Appeal was right. And that really the contractor shouldn't have been allowed to have terminated on that very simple basis. That if you've got a permanent secretary writing, that's good enough. So, as I said, people might delete clause 2.4 because if I was doing a project that was 500 million, I wouldn't want the employer writing to me say, can you prove you've got funding in the next 42 days? Because I can assure you it's really difficult. It's much easier to prove on your extension of at home that you can fund £10,000 because you can produce the loan agreement and you're in charge. But when you rely on many departments, it's really hard. And I've been on the other side of that, working for governments in different parts of the world, and I can assure it's really difficult. Early warning procedure. This is something that's in NEC but not in FIDIC, but they are looking at it and they might introduce something this week, but it's not in many contracts actually. It's quite a good idea. So how it works is this, is that if the contractor thinks that something is happening or might happen in the future that's going to affect time, cost or quality, he can warn the project manager. Isn't that a good idea? The contractor's on site thinking something's going to happen, I think, no one else knows, but I can warn the project manager. Project manager's informed, employer's informed, you can all start to think about it. And that's how it's supposed to work. Because then they're supposed to have a meeting, work out how to deal with that particular problem, and everyone's working as a team. And then it goes on to the risk register, and the project manager has to assess any additional cost associated with that. So it's a good way of the contractor saying, I think I've got difficult ground conditions, or I think this problem's coming up. It should mean you don't overrun in so much time, but what if the contractor spots a problem that's coming up that he's created himself? Would he give an early warning? might not want to. Would you want to give an early warning? The problem is that if you don't, and then later on it becomes a serious problem, you only get compensation as if you'd given an early warning. So if the contractor doesn't give an early warning when they should, they can lose their right to additional payments. So that's, again, carrot and stick, pushing people to give early warnings. It's the sort of the shove and the push behind good project management principles. And you've got it now in the Gould book. It's starting to find its way into the other contracts. As I say, FIDIC's got it a little bit in there in the Gould book. Fitness for purpose obligations. If you build something only to someone else's design, then you've got an obligation to use a good workmanship, satisfactory quality materials. If you design something, what's the standard? Reasonable skill and care. But if you make a product, it has to be fit for its purpose. So imagine you design something really well, it's built quite well but still doesn't work. That's not the fault of the designer necessarily if they're negligent. It's not the fault of the contractor if they followed the design. Does that make sense? But if you make a washing machine, it's got to wash the clothes and be fit for its purpose. You can't say, well, we designed it carefully, we built it really carefully, I'm sorry it doesn't work, because you would not be very happy. Same with a car. And the problem is if you're a contractor doing design and build work, you go from this world of design, build it, suddenly into having to deliver something that's fit for its purpose, and the standards are much higher. And in NEC, they try to water it down by saying that if the contractors use reasonable skill and care for design, then he's off the hook for the fitness for purpose obligation, which is exactly how JCT is written. Have a look in the JCT design and build form. It says that the contractor will only be measured as if they were a reasonably competent architect carrying out services of a similar nature for a similar project, and then uses good workmanship and good materials. If you were the owner, would you be happy with that? I wouldn't. Probably the courts won't either, actually, because they'll imply under Section 11 of the Supply and Goods and Services Act that something shall be fit for its purpose. Probably, but we don't know the answer to that yet. It's not happened. So these provisions might not work. I don't think the courts will like them, but this is to match what JCT does. FIDIC, on the other hand, is always a fitness for purpose obligation whenever you do design. Always in all of their contracts. Here's a bit about employers' claims. So remember I said to you that the employer, if they want to bring a claim, has to serve a notice telling the contractor. For example, the contractor's a year late, the employer can't just deduct liquidated damages without sending a notice saying you're 12 months late, it's so much per week, therefore I'm deducting 1 million, 10 million, whatever it is. That's a condition precedent to take in the money. And look, again, we've got the engineer making a determination about it. They go through that gateway before the employer can take the money. So the contractor brings claims, has to go to the engineer to get a clause 3.5 determination. Employer brings claims for delay, liquidated damages, same thing. It allows the engineer to divvy up who owes whom what. Now, in NH arbitration, the case we just looked at, the arbitrator there said that clause 2.5 is not a condition precedent. So what do we mean by that? It means that you don't have to bother serving the notice. But when it gets to the Privy Council, they say it is a condition precedent. They say that the employer cannot deduct any money from the contractor or even bring a claim without serving those notices. So it's really important. If you've got a clause like that in a contract and you are running the job for the employer and you see that the contractor has got problems, potentially got claims against them, you'd have to advise the employer to serve a notice or write it on their behalf. And if you don't and you're the contract administrator, you could be negligent. If the employer can't bring their claim because you didn't serve a notice for them, you could end up paying out that loss. So it's really important as professionals to watch out for those provisions. Yeah, so there's a bit more about that requirement there. So again, what would you do if you're the employer? Strike that clause out, wouldn't you? And here we are talking about trying not to amend contracts because they're nicely balanced. So if I'm the employer, I'd take out clause 2.4 and 2.5 to make my life a bit easier. Even if I was the engineer, I wouldn't want to fall foul of those things, so I could be negligent if I forget, take them out. But I do quite like them if I'm the contractor. Time and money. So let's look at time first. So the engineer gives the contractor a week to start on site under FIDIC, and off they go. And then you've got a time for completion, including passing any tests. If there's delays by the authorities, providing the contractor can show that they've put in all the forms and pushed the authorities for water and power and access and so on, they'll get time. And if the contractor is slow under FIDIC, well, the engineer can tell them to accelerate and produce a revised programme and so on and so forth. Then you've got delay damages, and unusually, the engineer can suspend the work. Doesn't normally happen under JCT. Why would you have a right to suspend under FIDIC? Well, imagine if you're working in a difficult part of the world. In fact, I've had projects in Iraq and Afghanistan where they've had to suspend works because of the problems and ISIS and so on actually blowing things up right by the site, and sometimes you just need to suspend the works and then you can restart it again later on. If it doesn't start within a limited period of time, I think it's 84 days, then yeah, there you go, then the contractor can terminate. You don't necessarily need suspension rights in the UK. Programme then. So the contractor has to give a programme of works within the first month, and it has to be revised as the works proceed. It's got to set out the order in which works are to be carried out and the stages for design and approval and so on. You can't manage a project if your first activity on site is clear the site and start excavating for the foundations, if it's design and build, can you? Because you can't do that until you've designed it and had it approved. All those things take time. Finishing the design, getting it approved by the local authority or the engineer. You can't actually start excavating and laying concrete and all those sorts of things. And people forget. I still get loads of programs, well, design and build programs, where the first thing is clear the site in the first week and start excavation the foundations, even though they haven't designed them. I don't know why people submit programs like that, but have a look. Have a look at your programs and see what you've got. You will see programs that just are impossible. This is because people don't spend much time preparing them. They take a generic program from the one they did before, adjust it a bit and stick that in. That's my experience anyway. I think 9 out of 10 programs don't work and will never work. Have a look at your projects and see. So the engineer can review it, comment, and then the contractor's supposed to update it, and away you go. Often what happens is the programs come late, they don't work, the engineer never approves them, and a year later the contractor is working to a program that was never approved and doesn't work, and then we all wonder why the project's in delay. And the engineer's having a complete fit but can't work out what's going on site. Maybe that's just the projects I get involved in, but I'll leave you to see how your career progresses with them. Extensions of time. So under FIDIC, now another important thing under FIDIC that you're going to have to look out for on all of your contracts in the future, because it's going to become more common, is the need to serve 2 notices. So what I mean by that is if you want an extension of time, you've got to serve a notice that says, please can I have an extension of time and identify the cause or the causes. You've given me a variation, I need an extension of time. Makes sense, doesn't it? But you have to, under FIDIC, serve a second notice or incorporate that into the main notice to comply with clause 20. Clause 20 sits at the back of FIDIC and looks very innocuous, but is quite a difficult clause. It says that if you don't serve a request for time and or money within 8 weeks of the event, 8 weeks under NEC, 28 days under FIDIC, sorry, you lose all your right to time and money. Gone. So you have to basically serve a notice which says we want an extension of time for this reason and we want time and money for that delay. If you don't serve those notices, the engineer doesn't know, it can't get to a determination, can never get to a dispute resolution procedure. So you've got to serve these notices. Modern international construction contracts are about managing the paperwork, serving notices, getting your programme straight. And that's very much the way that the position has become in this country because of payment provisions adjudication. actually internationally the world's behind, it's trying to catch up. So there you are, causes of an EOT under FIDIC, variation, substantial change of a quantity, and so on and so forth. Typical things you'll see in any contract. There's your NEC programming. Look, it's a bit of a shopping list of things you need. Same stuff as we just looked at, isn't it? Really? What do you need to have in a program or a project schedule? Start date, finish date, main activities, order and sequencing. This one, NEC asks you, have you got any hidden float, your own time that you're keeping to yourself? I would never show any, commercially, ever. Float is time that you could be used up without leading to an extension of time. You know, you've allowed 4 months for piling, but you only think it's going to take 3. You've got a month of float. So that month goes even before you have an extension to the planned completion date, doesn't it? Because you're not going to push out the completion date all the time you're eating float. And the contractor, in my view, needs every moment they can possibly get to work on a project. There's never really enough time. And actually, in the FIDIC subcontract, you get another list of things to show as well. So there you are, look. It's quite helpful, actually, if you're interested to see what should be in a programme. FIDIC's pretty good at that. NEC's pretty good at it too. And NEC really places the programme at the very top of its list because it's a project management contract. You need a programme right at the beginning. Every time there's a change, the programme needs to be updated. Every month, the programme should be updated. It show the planned completion date versus when you think you might finish. Because, of course, if you think you're going to finish next week, but you should have finished this week, there's a week of delay, so there's penalty damages. You should be able to manage that on the programme. Payment. The way that payment works under FIDIC is that the contractor submits their application for payment and the engineer is supposed to value it within 28 days. But it doesn't matter when they value it, really. The payment is always going to be 56 days after that date. So the quicker the engineer can get their valuation out, the better. But even if it's a bit late, it doesn't relieve the employer of paying. So that's how that works, 28 days and 56 days. Even at the end of the project as well. But this period, you know, the final payment could be pushed out because you're waiting for the final account, the final statement, but then you fall into 28 days and 56 days. So it's a bit of a sudden push. I mean, the final statement is supposed to come along within 3 months, but it could be 6 months, 9 months, a year, requesting a huge amount of money. And then traditionally what happens is very little is certified, and then you spend time arguing about it. Maybe it's settled, maybe it's not. Price and payment. Well, bill of quantities, yes, you can have them internationally, but they're very rare. Advance payments are more common. And an advance payment is a loan of money, really. So imagine that I want to build a power station and the contract sums $600 million and the turbines are going to cost $100 million and they need to be ordered 18 months before they're going to arrive. The contractor can't place that order until he's got the money. So what you'll do is you'll give them the $100 million up front. They'll use it to sit in the bank account and place the turbine order. And the turbine manufacturers won't start making anything until they know they can get their hands on the money, because there's very few of them in the world that do it. So if you want their product, you're going to have to demonstrate you can pay for it. And then that advance payment is slowly taken off the interim payments until the money's recouped during the course of the project. How do you protect it? Imagine that you're going to give a contractor $100 million. There's $100 million, they're just starting on site. Where's the value? Well, the only way to protect it is to get a bond from them. So you give them $100 million, they give you a bond to the value of $100 million, which means if the contractor goes bankrupt, loses your money, spends it on stuff, then you can go to their bank and get the money back. And the bond reduces as well. So as you get to the end of the job, the bond becomes worth zero, but of course by then the project has been finished and the turbines are on site, you've got value. Does that make sense? So that's how you manage your financial kind of commitment in relation to advance payments. I always remember one of the famous football players, I can't remember, I think he's dead now, one of the famous football players was being interviewed years ago, and they said to him, you've made a lot of money over the years, but you're broke now. What kind of happened to it all? And he said, well, I basically, I spent loads of it on fast cars, booze and women, and the rest I just wasted. So I can't help but think of that when I think of advance payment and what contractors do with it. On completion then, yeah, so there we are. So we just talked to me about getting that final certificate through. There's a nice mechanism there. So the idea is you go through the project in FIDIC, trying to value change, and at the end, you then go into a traditional JCT type approach of final account. What did we really spend? What have we forgotten? Have we served a notice against something we can claim some more money? And you go through that process. Doesn't happen with NEC. There's no final account process in NEC. So how do they deal with it? They just have compensation events. Now we spoke about extensions of time a moment ago and payments. If you go to FIDIC, JCT, all those contracts, they separate time and money. If you want an extension of time, that gets assessed. And then money comes separately. So imagine there's 100 variations on a project and you manage to work out that you need a 6-month extension of time for that, and you get a 6-month extension of time. That's just relief from liquidated damages. What do you need on top of that? You need the 100 variations valuing, don't you? The physical works on site created by them. But what have you forgotten? You've been on site for 6 months longer. You also need the prolongation cost of being on site, don't you? The site setup, prelims, whatever you want to call it. So you need to get that valued, and loss of profit, and the increase in insurance for being there longer, and the cost of maintaining the bond for longer, and head office overheads if you've got head office overheads. Do you see? There's a lot of other things. And so that's why you, under JCT, FIDIC, look at time, work that out, and then how much. NEC does not do that. It's the only contract that doesn't. NEC's philosophy is that if you have an event that has any impact on time or money, then you have to value it completely in terms of time and money. So if you've got a variation and it leads to 3 extra days on site, then you get your 3 days, the cost of the variation, and the cost of all the prolongation costs that go with it. A little tiny bit of extra money for the insurance, a little tiny bit for the bond, all in one go. And if you don't pick it all up there, you never get it because there isn't anywhere else to get it. So this is the good and the bad thing about NEC. The good thing is every month you should be looking at the compensation events, time and money, and in the following month when the valuation is done, actually adjust the programme, get an extension of time within the compensation events and agree the extra money. So the contract sum slowly goes up, the contract date gets pushed out. And if you manage a job like that every month, I mean, that's a great way to manage a job. Every 4 weeks, you know where you stand in the future. It's a really good way to manage a job. Until you lose a grip on it, and then you don't know where you are. When you end up with 100 compensation events a month and they don't get dealt with, and 4 months later you've got them everywhere and no one knows what the programme looks like. But it's a great way forward, because the problem, of course, in that scenario is there isn't a final account at the end. So you have to go back and try and sort them all out as you go. But it's a different way of dealing with the contract. It's a good way of dealing with it. I quite like it. And there we are. Now, this is the time bar in the NEC. Where is it? Can you see on there the 8 weeks? Yes, so if the contractor does not notify a compensation event within 8 weeks of becoming aware of the event, he's not entitled to a change in the prices. So basically, if you don't give me a notice within 8 weeks of thinking you need more time or money, then you lose your right forever. It's really tough. If I give you a variation order and you don't tell me how much extra it is within 8 weeks, I'm not going to pay you for it, and I've got no legal liability to. Seems tough, but it does make contractors put in claims regularly. And if the employer doesn't receive regular claims, they can't manage the job, can they? So it's sort of, you can see why it's done like that. FIDIC is the same, but it's 28 days. And there's the FIDIC one. No later than 28 days after the contractor became aware. Just focus there for a minute. This is the real argument. This is where we have all the arguments in international arbitrations is, well, when should I, as the contractor, become aware? Yeah, imagine I've got 6 months in my programme for excavating. 1 month in, I start to find the ground is harder than I thought. More obstructions. Another month in, it's getting worse. Another month in, I start to wonder if I'm losing time. 4 months in, I serve a notice saying, I think I'm delayed. Now the engineer's going to say, you knew in month 1. Therefore you don't get any time or money. But I've got the right to say, but you know, in the first 6 months of the job, I thought I could cope with it, and the job's 4 years long, and maybe I wasn't going to be late. But my optimism has gone, and I'm probably going to get the benefit of the doubt. But you can't serve these notices after the contract's over or when the job's at an end, because you're just going to be in real trouble. So you do need to make sure that you're notifying, and this is a real problem for people. NEC guidance note, you know, basically does say, it tells people that they're going to lose their right if they don't serve these things. The FIDIC guidance note says the same. What about the law on this? So the case called the Bremer is actually about property, and it's about leases. And the judges made it very clear. House of Lords, 1978, so that was the most supreme court in this country. It's now called the Supreme Court. Said that if you don't serve a notice and the contract says you've got to do it within a certain period of time, you lose all your legal rights. That's the way it is. Multiplex and Honeywell is the first case in this country really where that was tested out properly. This is Wembley Stadium. So in Wembley Stadium, we acted for, in this case, for Multiplex, the builder. Honeywell did the electrical systems there. Honeywell brought a claim for 11 million. They hadn't served any notices, and so we refused to, well, our client refused to pay. Went to the High Court. Lord Justice Jackson was the judge, and he basically said to Honeywell, how difficult is it to serve a notice? You're professional people, you've all got qualifications, you're chartered surveyors and engineers. Surely you know you're supposed to serve notices. The contract says you're supposed to have served them. The Bremer says that if you don't do it, you've lost your rights, so therefore you lose all your rights, you've waived all your claims. City Inns says a similar thing. Walter Lilly tries to find ways round it. O'Brascon and Gibraltar makes it clear that you lose your right. And back to the NH case, well, that's on the clause 2.5 notice. Do you remember where the judges at the end said, no notice from the employer can't bring a claim. So it's really difficult. You've got to keep an eye on this now, especially if you are contract administrator, because if the employer doesn't serve a notice but is relying on you, you could become liable for the losses. And that's what's currently happening now as a result of these cases. Mitigating the time bar. Well, there's ways around it. You know, when was I aware? Have I served a notice in an email? Is that good enough? Is my progress report good enough if I list in my progress report delay events and money events? That can sometimes be good enough. But these provisions are getting tighter and tighter. You've got to look out for them. There's some conclusions. Look out for them. Don't ignore them. They mean what they say. I've already told you about this bit actually. So this is in terms of assessing compensation events. Time and money all dealt with in one go. That's what the provision actually says. The strange thing then about compensation events is under NEC, and again other contracts do not do this, is that the assessment is done by looking forward. Do you see what I mean? So imagine you're on a typical JCT contract and you've got a whole schedule of variations on the project that took place during this year. We could sit down now and value them based upon what actually happened, couldn't we? We could say, well, that variation looked like this, and we've got the invoices for it, we've got timesheets, we can make an assessment based on the rates, we can value it. NEC says that's not good enough. You've got to value change today and what's going to happen tomorrow. So in other words, if we've got a change issued now, and that variation is going to be carried out next month and the month after and the month after, and the compensation event notice is issued, we as a project manager have got to value it now. So we're going to have to look forward and think, well, it's probably a month extension of time and it's £1 million, and here's the categories of cost, and you assess it and you're then stuck with it. So it means if it isn't a month, well, maybe the contractor gets a bit of windfall time. If it turns out to take 5 weeks, the contractor loses a week. But can you see that philosophy? The philosophy is we're going to work out now what we think the impact on time and money is, so the employer knows where he stands and the contractor knows how long they've got and how much they're going to get paid. And if we're working on rates and prices in the contract, well, that's what we're going to get anyway. So it incentivises everyone to get on with the contract. Does that make sense? It's quite different to JCT, which is what did it cost? Let's look at the cost. Termination. So here we are now in the dying kind of throes of the contract. Termination for default. So if the employer issues a notice to correct requiring rectification within a reasonable period and the contractor fails to comply, this is under FIDIC, then the employer can terminate. So this is where the contractor's not doing their work properly. They get a warning shot. That's the notice to correct. And then if they fail to do other things, not provide the bond, that's what performance security is, or they abandon the work, of course, don't push the works on with due expedition without delay, or they assign a subcontractor to do all of the work, it gives the employer a right to terminate the contract. And there's the standard, box standard one, becomes insolvent or something. I mean, if the contractor's insolvent, you get an automatic termination under JCT, just the same here. You can't obviously continue a project with an insolvent contractor. Nothing's going to happen. Now, I've mentioned this other case, the Abrascon case. Let's have a little bit more of a look at that case. So this relates to a runway at Gibraltar Airport, and it was a 2-year contract. And 2.5 years later, with only a quarter of the work done, it was terminated. So it all relates to these provisions in FIDIC, Clause 15, which is where the employer can terminate. And it looks at the notice provisions under Clause 20 as well, and the liability of the contractor in relation to the information in 410. We looked at that at the beginning. This is the works information given to you, or the design and works information given under FIDIC. Here's the site data. This is quite interesting. So this is in your standard FIDIC contract. The contractor is responsible for interpreting all data. The contractor shall be deemed to have obtained all necessary information as to the risks and contingencies and other circumstances which may influence the price. So this is a deeming provision. Let's just stand back and see how we know, or we now know, how this operates compared to what we thought. The contractor gets some site data, borehole information. They make an assessment about the ground. The ground looks okay to dig in. They start on site and it's much worse. They bring a claim because the site data information showed the ground was fairly soft and it's rock hard and we're struggling. That would be a fairly good claim, wouldn't it, normally? A judge basically said here that if you've got sketchy ground information and it shows the ground's all right, but you could examine local authority details and go to site and have a look and make your own investigation and realise the ground's really bad, then you're deemed to have done that, even if you haven't, and it's in your price. So the employer had done a desktop study indicating there was 10,000 metres cubed of contaminated material, and the contractor, the Court of Appeal basically held that the contractor can't rely upon that. He has to actually consider that there could be a worst case scenario. I find that surprising because I think contractors price optimistically on the best case scenario. Don't they? That's what they do. If they always put in the price for the worst case scenario, they'd never win any work. So I'm a bit surprised by that, because this judge at the TCC is very experienced in relation to this sort of stuff. Anyway, there we go. But I think it's really tough on the contractor because it's not what contractors do. But I can see from the language of the contract how it works. So could the employer terminate? Because the contractor was saying the ground was so awful, it was going to take 4 years, not 2.5. It's all your fault, you can't terminate. You can see where this is heading now already, can't you? A notice to correct should only be issued for more than significant failures. So you can't terminate a contractor because they're just messing around a bit on site, or things are defective that they can fix. It's got to be a big problem. Nothing trivial. And a breach need not amount to a repudiatory breach. Do you know what that means? What's a repudiatory breach? It's the next thing up. Yeah, so if you've got a contract, and see where you're heading, if you've got a contract and you breach it, if the breach can be remedied by payment of money, then you get a payment of money. If it can't, then you can bring the contract to an end. So if I'm the employer and you're the contractor, and I don't give you access to the land, how do you do your work? You can't. It's a repudiatory breach. Brings the contract to an end. But if I give you access to the land and you're working and I interfere with what you're doing, I give you variations and I give you lots more to do, well, that doesn't let you bring the contract to an end because I'm in breach and I just have to keep paying you for all the aggravation I cause you. Does that make sense? But if I bar you from being on site, it's repudiatory. So what he's saying is it doesn't need to be a huge breach either, not a little one, not a huge one, anything in the middle is fine. And it has to be issued in relation to actual failures. So this is difficult because if the contract is 2 years long and you're 18 months in and the contractor's only a quarter of the way through and they're never going to finish on time, can you say to them, I want you to finish on time? Because there's no actual breach because they haven't passed the date for completion. 18 months into a 2-year contract. Here, the contract period was 2 years and they were 2.5 years in, so they'd actually failed already. And so there we go. So the judge came to the conclusion that the failure by only being a quarter of the way through the project way after the completion date was substantial. It was a good enough reason to terminate the contract, and the contractor couldn't rely on the fact that the site data was not very good because they should have investigated it better. So the first bit I completely get. You know, the contractor wasn't actually progressing it quickly enough. They hadn't really got on with it. And in reality, when you look at the facts, they were sitting around. But that's a bit of a sideshow, really. I think it's quite tough on the site data front. But beware. If you're working for a contractor and you've got a normal contract that looks very kind of easygoing, but there's an amendment which says you are deemed to have investigated all site conditions and allowed for all risks and contingencies in your price, you're really going to struggle to bring claims for time and money if you have difficult ground conditions or contamination and so on, which is not good news. Claims and dispute resolution. So just having a quick look then at FIDIC. We now know, you've probably talked about adjudication, you've probably talked about arbitration, but to get there is quite a thing under these contracts. You've got delays and additional costs and variations. You're trying to work a way through to agree how much with the engineer. But if you really find yourself wanting to bring a claim and fight using the dispute resolution procedures, don't forget then, you're going to have to now go through clause 3.5. It's not quite every claim. There's a few areas where you don't need to do that, but mostly you need this 3.5 determination. You need your notice of claim as a condition precedent. That's your clause 20 stuff. You need loads of them throughout the project for all of your claims for time and money. You then need to form a dispute. So, in total I need 2-year extension of time and $20 million. You can refer it to your dispute board. Is it standing or is it ad hoc? What do I mean by that? Well, under the FIDIC Red Book, that's traditional build, you appoint your dispute board at the beginning of the job and they follow the project all the way through, and if there's a dispute, you give it to them and they give a decision and away you go. But the Yellow Book's not like that. I think it's unfortunate. The Yellow Book says you only appoint your dispute board when you have a dispute. So you've got a 4-year contract. 3 years on, you've completely fallen out with each other, hate each other, can't talk to each other, there's loads of claims, and then you get your dispute board in place. No one can agree anything. If it's a red book and you appoint them at the beginning, the dispute board members get to know the contractor and the employer and the engineer, and they all get on. So when the contractor starts falling out with the employer, at least those people can still talk to the dispute board, because the dispute board's independent, and the dispute board knows the personalities, knows about the project. so they can make better decisions. And they only get 84 days. Okay, here domestically you get 28 days, but on these bigger projects, you know, the referral might be 10 million, 15 million, 40 million dollars, much more complicated disputes. I had a dispute, well, one of the disputes I was representing a contractor in a while ago involved a road project in a very difficult part of the world which was terminated, and the other side refused to accept that the project was terminated properly. The first thing we had was a certificate that hadn't been paid for $8.5 million, so that was pretty good because, you know, it's a clear breach. But the circumstances of termination was that the government in question decided that they didn't want my client to leave site. So there was a security force within the site protecting the site. It's in a difficult part of the world, and the external security force, which was the local army/police force, because they're combined. And the government decided to hold my client on site by turning the security force on the site. So rather than the security force protecting, they kept people on site on the basis that they thought if they kept them there and took their passports away, they might like to finish the job before they went home. Didn't go down very well. That basically led to about a week's fraught discussion between 3 embassies, and eventually ended up in spending $150,000 sending in 3 helicopters and a private security force to get them out. So 2 big helicopters held everybody off while the little one landed and got these guys out. And it was fun interviewing them, because I said, would you go back there again? I can't tell you what they said because it's really rude, but it was along the lines of, I'd prefer not to, thank you very much if you don't mind. Actually, that wasn't it, because there was one guy that said you definitely go back. Some of them like living in interesting places. Anyway, so we had an 84-day process in relation to did we terminate properly. So you can imagine that was quite an argument about that before we moved to how much afterwards. DAB gives a written decision. This is quite interesting. We're now at the pathway, kind of go either way under FIDIC. If you don't like the decision, you have to serve a notice within 28 days. It's a nod. Notice of dissatisfaction, don't like it. That means it doesn't become final and binding, but it's still binding. And if you don't serve a nod, it becomes final and binding. And then you go to arbitration just for prompt enforcement of the decision. Whereas if you've served a notice of dissatisfaction, says you don't like the decision, you go off to arbitration after you've tried an amicable settlement. You've got 56 days to try and have a mediation. We actually had one in that case for 4 days. No one agreed anything at all. And then off you go to arbitration. But the important point is you're supposed to enforce it quickly in the meantime, just like you would adjudication here. But trying to do that internationally is a complete nightmare. And it's just not understood. There's a case in Singapore that went on for 6 years trying to enforce some of these things. Eventually they did, but what's the point? 6 years later, you want immediate enforcement, don't you? That's the purpose of DABs. So that's a quick timeline with our dispute events. So that's trying to kind of put it into a bit of a timetable for you. You know, you've got your commencement date. This is under the Red Book. You're supposed to appoint your DAB within 28 days, and then you get your referral to the DAB with a written notice, decision here 84 days later, and you've got 28 days to decide whether you like it or not. If a notice of dissatisfaction is given, you've got your 56 days from some sort of mediation, and then after that you can appoint. So what I'm really saying is, if you've got a dispute here, you can't get to arbitration until at least there. You know, in one respect it's good because it gives you a cheaper, quicker process and you might have a mediation. But if you already want to kill each other here, you're just delaying this point. So, you know, there we are. So there we go then. Red book is standing. Yellow book is when the dispute arises, in my view, too late. You appoint your DAB members and you have a tripartite agreement. So you've got 3 DAB members, 2 wing members and a chairman. And if I'm the contractor, then I've got to have a contract between me and the employer and the dispute board member. So that's what I mean by a tripartite agreement. We all have to sign up to it. and that governs our relationship and who pays us. It's paid 50-50 between the employer and the contractor. Normally what happens under FIDIC is the contractor pays all of it and claims back half in the interim valuation, so that's how it works. There's procedural rules about who does what in terms of what powers the dispute board has, and if you can't find any DAB members, then FIDIC's got a list of adjudicators, and you can go to the president of FIDIC and they'll appoint someone. There's quite a limited list. There's 60 people in the world, I think, that are on that list. I'm one of FIDIC's adjudicators, and I do a bit of training with some of the others. So from time to time, we end up with 3 or 4 of us in one room together. I'll come back to, just before I go on to the NEC, I mostly act for parties, but I do sit as a DAB member from time to time in interesting parts of the world. At the moment, I sit on CERN's dispute board. I don't know if you're aware of CERN, the nuclear research facility in Switzerland. It's the Hadron Collider. I don't know if you know what that is. They discovered the Higgs boson in 2013. And if you don't know what that is, they discovered something called the God particle. That's what they do. Is they basically fire particles at each other so that the atoms, well, in fact, it's not atoms. They split the neutrons off and just fire protons, so it's positively charged only for those of you that are into this stuff. And when they hit each other at the speed of light. So they fire them around a 27-kilometre tube, 100 metres underground. When they hit, they fracture, and they basically take a photo of it, for want of a better word. It's much more sophisticated than that. But they take photographs of how these protons split apart to see what they're made up of. And what they're looking at is the matter that holds particles together. So this technology is what led to CAT scans, for example, in the hospitals. And has led to things like the fusion project that's in France. I don't know if you know about that, but in Egan in southern France, they're building a fusion power station at the moment. Does that mean anything to you? This is the most interesting project in the world, I think. So how does a nuclear power plant work? It's a gigantic kettle, isn't it, basically, the turbine. It heats up water, and the water spins the turbines, which creates power. But the way that you get the heat is what's interesting. So in a gas power plant, it's basically the gas being burnt to create the heat. In a nuclear power plant, what you do is you take the heaviest metals you can find and make them unstable so that you get enormous energy release because the energy is given off. So that's at this far end of the scale. If you go to the very other end of the scale, the lightest possible elements, hydrogen, oxygen, there's nothing much to them. But if you can fracture those, they give off 10 times the energy. The waste product at this end is radiation that kills us. What's the waste product when you fracture hydrogen and oxygen? Water. So imagine if you can build a power plant, same size as a nuclear plant, that gives you 10 times the power, and the output is water. So they've been trying to do this for years, but no one can ever get it to work. Anyway, they're building a plant in southern France, and they're halfway there, and maybe in 10 years they'll finish it, and if it works, they'll have a blueprint for making fusion power plants. So that's one of the other things that came out of CERN. So they're just about starting their next 10-year project where they're going to increase CERN, and there's a panel of 5 adjudicators, and I'm the chairman for that. So we're going to be monitoring the design and the construction of all these different things. The boring stuff, as they call it, which is the bit I like, which is the tunnels and the tunnel boring machines and the shafts, and then the bits that go in it, which everyone else calls the toys, the Hadron Colliders and the magnets and stuff like that. But have a look at CERN, it's quite an interesting project. So you do get involved in some interesting stuff from time to time. But all based on this, it's FIDIC Red Book, and the design consultants have got a FIDIC-based contract, we've got tripartite agreements, procedural rules, all that stuff. So no matter how sophisticated the project, you end up with this sort of stuff if you're going to have these procedures in place. Adjudication under NEC is compulsory. That's one thing that's interesting about it. So it doesn't matter if you're in this country and you end up with W2, because W2 is the 28-day process, or, as I say, I've got projects in Dubai at the moment with this, you end up with W1 in Dubai. The Housing Grants Act doesn't apply, you get a bit more time. It's a bit more loose because people are not used to 28 days. You still get the adjudicator's contract, which is a tripartite agreement, isn't it? employer, contractor and the adjudicator. And the nice thing about NEC is you've got lots of guidance notes and flow charts and all that wonderful stuff, which I never look at, ever. Well, I do occasionally. The danger of looking at guidance notes is it misleads you as to what the contract really says. You know, someone that's written the guidance notes has written what they thought or think or hoped the contract says. And judges frequently tell us that the contract didn't mean what we thought. So it's much better to start with the contract and go from there. Okay. Well, you can have a look at that. There's a few more cases there in relation to the NEC approach. But basically, this is the last slide. So basically, if you look at NEC and you look at FIDIC, they're contracts for mega projects. FIDIC's used everywhere around the world. NEC's used just here, a bit of Africa, good again for big projects. But the approaches are quite different. Although there's a lot of overlap with things like time bar, time and money is dealt with quite differently in NEC. It's all forward-looking, one thing at a time, a lot of heavy program management, whereas FIDIC is a bit more traditional. But they do have time bars, and they do use adjudication in different ways. So in NEC, you've got one adjudicator, even if it's an international project, whereas FIDIC has a panel of 3, and they try to have a dispute avoidance function before getting to disputes. If they're following a project, well, then they can help you avoid disputes. And that does work. Whereas if you just get your adjudicator in at the last minute, well, there's not much you can do at that point. Record keeping is important to back up your notices. Try to deal with change as you go. That's really very much how these projects work as a general conclusion. So, we've got through it all, I think. But if you've got questions, I'll take them.
Hello. I wanted to ask about NEC early warning procedure. You were saying that if contractor sees something on site, but he might not want to say anything about it if it was his fault, but how, as a client, how do you prove it that he saw it but didn't report?
Yeah, well, it depends on the nature of it. But for example, imagine that the contractor claims a compensation event for something that's going on site now. But then the employer, when they look at the records, or the engineer, when they look at the records, realise the contractor has been behind for months and months because one of their subcontractors went bankrupt. Yeah, so subcontractor goes bankrupt 3 months ago. The employer thinks, I'm really going to be behind while I replace them. The records are going to show the site labour goes down, production goes down. The engineer might not notice this. And then, of course, the contractor waits until something else happens and then blames the delay on that. But when you start to look at the records properly, you start to realise it can't be that because they're already behind. What was it? And you go back and you see what it was. And then that would mean you've got a double-pronged approach of saying, well, it wasn't that event, it was that. And even if it wasn't, well, you didn't warn us about that event, therefore you get no time. It gives you that sort of possibility. Another one might be difficult ground conditions. Do you remember my example of 6 months and I don't tell them until near the end? Well, that might be good enough for my clause, my time bar clause, but actually on that first month, when I spotted difficult ground conditions, I should have given an early warning. So I might only get my assessment for a shorter period anyway, even though I don't fall foul of the time bar. Does that make sense? Yeah. So you can see it's really forcing the contractor to say, difficult ground conditions, don't think they need any time or money yet, but just so you know, then you're supposed to have a meeting and discuss it. The following month you monitor it. And the contractor doesn't really like the engineer turning up and monitoring stuff.
Thank you.
Until you know which way it's going. Thanks.
Just on that point, would you not say as a mitigating factor, the mere fact that there are monthly progress reports issued in the program, surely that indicates in some instances that there is a fault here somewhere?
Yeah, but do you know, often people don't interrogate them sufficiently. You know, a typical progress report on a big project might be 300 or 400 pages long.
But then would that be a justifiable excuse to say, oh, we didn't look at it properly?
No, but it doesn't necessarily reveal what you might want to look at. For a good example with progress reports is the photos. It only reveals the photos that are taken. And people tend to take photos of the interesting stuff on site. You know, they tend to take photos of things that are just about to start, or it's just finished because it looks nice. You actually want the photos of all the things that are half done, and you often don't get that. Because if something is half done in every progress report, you know nothing's progressing. But often when you see progress reports of things started and things finished, and you can't tell what's going on in between. Have a look at them. Often that's the case. But yeah, no, you're right, it's weird. In hindsight, when you look back at progress reports, you can see evidence for what's going on. But if you're trying to assess all the things that might be going on this month or last month, it's quite hard. Nature of construction projects. And sometimes labour rates dropping aren't indications that things are going wrong because you might have finished a very labour-intensive item of work.
In a minute, please, Mark.
Yeah.
I have a question as well. I'm sorry.
Okay.
Before you, I have the privilege. I have the microphone in my hand. You were saying about provisions for float in the program, which is, from my side experience, and I think it's almost impossible because you contractors do everything to gain new clients and new public procurement contracts especially, and they generally consider very, very, very optimistically everything. They generally don't even see the conditions of the grounds and etc. And they generally start with the machines on the ground before having any guarantee that everything is going on. How can you live without claiming in construction company? How can in construction contracts?
It's the only way they make money.
So you start a contract definitely considering that you're not finishing time, you won't be able to do everything in that specific time that you're promising, and you'll definitely claim afterwards.
You start on the basis that you're going to manage the contract carefully, and if things go wrong, you're going to try to bring claims and manage it, because if you don't, you'll go bust. You know? And if you always price things fully, you'll probably never win any work. So I've got some of the good clients I have internationally work on some really difficult projects, and one thing that they all have in common is that they endeavour to get projects finished no matter what. You know, if you terminate a contract and go, it's a bit of a disaster. Whereas if you finish a job, and even if it's many years late and has cost more, at least you can try to bargain over the completion of the additional time and money. And it gives you a right and a chance to more money. So most of them persevere and try and get things done. And then have to, you know, if they don't get paid, well then they bring claims and I go and turn up at their dispute boards or their arbitrations and fight their corner for them. But it often, a lot of the contracts I see are rushed in the way that they're put together. In terms of the contract documentation, still has holes and gaps and is wrong and the concept doesn't work. And
Bad drawings. Yeah.
there's always ways in, usually, you know. If you find a perfectly well put together contract, well then the contractor's in trouble. But often they're not, no matter how beautiful they may appear on the outside. Right.
You must have a good cash flow for you to maintain your business while you're late.
That's why it's the big contractors, the big international contractors that are well supported, are the only ones that survive. Otherwise, they go under. Yes.
Thank you, Nicholas. Just stressing on what Angelica said. In regards to NEC contracts, is there a contractual obligation where the contractor is supposed to show in his program any float?
Yes. So, but, I mean, would you? Imagine you have a month float in your program and then the contractor gets given a variation which leads to a month of delay. How much extension of time do you get? None, because all that's happened is it's eaten your float. So what a pain. You've lost your float. and you now, if something happens that's my fault as the contractor that leads a month's delay, I'm going to pay liquidated damages because the employer's already eaten my float. That's not good, is it? I used to work with a delay consultant who's retired now, and he would always say float is just such a mystery really, because he's never ever seen a project, and neither have I actually, where when it's finished and you look back at it, there was any float. Contractors don't reach a point where they think in May, hey, there's some float, let's stand around for a month and it won't have any impact. If you look back on a job, it's either progressing well, trying to catch up, or contractor in delay because of their own fault, not enough labour, big variations, we're behind. You know, projects are usually quite hectic and dynamic. When you end up on a project that's just not being managed, the contractor is just in delay, but it's still not float. So it's much better when you, I mean, this is the NEC problem, is looking forward, you having to use float or maintain float. But actually on a JCT project where there may have been float, it doesn't matter because you look retrospectively at what caused the delay, and it becomes, in my view, in most JCT backward-looking disputes, it becomes irrelevant float.
It's going to be our last question.
My question relates to bonds, which is a special requirement on the contract. Now, should the contractor fail under his performance under the contract, and whereby it leads to the employer terminating the contract, can the employer call for the on-demand bond immediately? Yep. Because bond is equivalent to cash for them to, you know, yep, have a substance to complete the job, or yep, does he need to wait for somebody who's in power to tell him you can call for the bond, otherwise it can be a dispute?
So if it's a pure on-demand bond, which means it can be called at any time with a written notice, and that written notice being evidence, conclusive evidence of the breach, then they can call at any time. But yes, in reality, in the background, again, if I'm a Ministry of Transport person in a particular country, I might need internally to go to someone to get authority to call on the bond. But the organisation can call on any time they want. But sometimes what holds up governments is getting the authority to call on the bond, because no one wants to do it necessarily. They may feel annoyed and they may want to get the contractor's money, but no one wants to have that responsibility of being liable for the one that calls the 20 million bond and then gets fired afterwards because the, yeah. So usually for a government to call it, they need someone quite senior, and that would normally be head of legal in that a group that would have to give advice, written advice. And sometimes they come to people like me externally to write advice about calling it or not calling it, so they can blame me, which is fine. Yeah, but say a corporate business can just decide to call the bond. The chief executive can say, I want to call that bond, and they do it.
And the bank wouldn't, reject it?
No. We just, we've actually, funnily enough, we've just acted for a we were acting for, contractor in Trinidad and Tobago again, and got the court to order them, Santander, to release $50 million last week, which they refused to issue. So we got a court order telling them to release it. So, yeah, if they don't release it, you'll get a court order promptly in most countries for quick release.
Just a quick question. What is the main reason that a client, a contractor / subcontractors go into dispute? Is it because clients / contractors employ incompetent people? Because going into dispute, just going back what you just said earlier with regards to the pictures that we take in the beginning of the job and at the end, if a professional company puts something in place like monitoring of progress, monitoring the subcontractors, monitoring every single activity that goes on site, I don't believe that we have to go into dispute.
In my view, the real underlying fundamental pinpoint start for all disputes is unreasonable expectations. And that leads to unreasonable positions, which leads to someone saying, I can't pay you for that because. Does that make sense? I mean, you know, you can trace disputes sort of back to unreasonable positions, which is unreasonable expectations on a project. But it might also be a failure to understand that you've got liability. I mean, I've got a contractor at the moment on a project that's a design and build project. It's a turnkey, Silverbook project. And they just refuse to accept that some of the initial delays are all their fault, because what they did was they knew they had to put in a design. So they put in a design and they kept getting comments on the design and they kept changing the design. They've blamed the employer's engineer for all these comments, but the employer's engineer says, well, there just wasn't enough information in the design. I'm not actually the engineer, I'm only the employer's representative. If the contractor had given me all the design, I wouldn't have tinkered so much. And I said to the contractor, well, you know, you've taken on responsibility to deliver this thing with a certain output. It's hard, really, to bring a claim when you are just liable for it. And you may feel aggrieved, but you're never going to win this claim in an arbitration, because you always have the responsibility to put in a complete design promptly and then build it. And they'll say to me, well, what am I supposed to do if the engineer, employer's representative, keeps making comments? I say, just build it and get on with it. Because you can say, we're the contractor, that's our design, that's what we're doing. You've given us that responsibility, that's how we're delivering it. You know, there's usually an answer, but not always. But I mean, the other way to look at disputes is to look at the little details of, you know, variations and change in ground conditions. But you trace it back, it's a unreasonable expectation, coupled with a bit of lack of knowledge and then unreasonable people, which makes it much more fun.
You mentioned site information, which are substances to the work information. And I believe that the site information, just like a soil investigation and the like, is to help the contractor to price for his preliminary cost item.
Exactly, yeah.
Which doesn't relate to the measured work or any activity.
Yeah.
So as such, I don't see a contractor coming back with a claim saying, you know, making a complaint about the site information that is not correct. I feel it doesn't look nice. It's not going to be accepted.
But if I gave you some boreholes of the site, so I gave you 4 boreholes of the site, and the ground looked quite nice, easy excavation, and when you turn up on site, it turns out that most of it's rock and the boreholes weren't a true representation, and it's going to cost you twice as much to do the excavation, you'd feel like you got a claim, wouldn't you? What if I say, tough, I gave you the bore information, I said it might be wrong. You'd be really annoyed. And if I said to look, the works information says you're deemed to have taken into account, and that judge in Gibraltar said it's all your fault, you'd be really annoyed. You know, I kind of think that the site data, and my traditional view until I saw this case, was that the site data is to give you a benchmark for the way the contractor's going to build it and so on. And if it turns out that the borehole information is badly wrong, then it gives you a benchmark to pay the contractor some more money or give them some more time. Because you know that they're pricing it as cheaply as possible based on the ground information. But that's not really the way it's heading, which is interesting.
Yeah. So, last one.
Yeah, it's all right. I don't mind, it's all right.
Last one. I know you're in a hurry to go, sorry. Like we've been saying that FIDIC is being used internationally. Does it mean it cannot be subjected to adjudication at all?
Yeah, I've used FIDIC here. Actually, I used the, which one did I use? I can't remember now. I think I used the Silver Book once and the Yellow Book here. And what you have to do is delete the dispute board because it's 84 days. Because if you've got an adjudication process that takes 84 days, what does the Housing Grant Act do? Section 108, non-compliant. Therefore, Section 108 deletes the entire dispute board and replaces it with the scheme.
Okay.
Yeah?
That's right.
But so it's much better to delete it and put in your own scheme.
That's right. Thank you.
Yeah. Okay. Anything else? No?
A last question. Because I'm afraid we ran out of time.
I had one, but I thought it's not.
Yeah, go on. Go for it.
Mark. It's going to
I
be the
don't
last
mind.
one anyway.
It's not necessarily related to this, but I thought
That's all right. Anything you
something
like.
I'm actually sort of dealing with. I'm working on not naming any person. I'm working on a contract where it is more similar to ICE contract.
Yeah.
But it's more, the client has actually more amended it to suit their own And the pricing mechanism that were originally inserted in the contract was a fixed price mechanism. And this contract is based on a zero value. So anytime there is an instruction issued out, that's when there isn't a framework agreement. And anytime that there is an instruction issued out, that's when the contract kicks in between the contractor and the client. I've been brought in to come and do a bit of a, what I would say, agreement of a prices, which, to my understanding, I thought it was a fixed price should be agreeing to the prices before works actually commences on site.
Yeah.
And I'm finding it hard to.
But an ICE contract traditionally is a remeasurable contract. Yeah? So the only thing fixed in an ICE contract are the rates, not the measure.
Not the measure.
So at day one, you start with zero value and zero measure, and after the first month, you measure what you're doing and you just apply the rates, and it becomes what it becomes. So you could have a ICE contract for £10 million and it ends up costing 30 because that's what they do, and there's no actual change to the fixed unit prices. The works has just expanded beyond all recognition, and the contractor gets paid, and they may make money or lose money based on the rates. So you do need to know where you're starting. But I mean, JCT is a lump sum in that the price is for everything, and then variations adjust that. What you can't do is have a fixed price for everything and give variations, and the price doesn't change, because there's always a right to extra money. If it's not under the contract, then it's in something called the law of restitution, most likely. But you do have to check to see whether things are inside or outside of the scope very carefully. If it's been amended in a strange way, then you need to look at it very carefully. I mean, I see contracts that are amended in all sorts of ways, and we bring claims in ways that people don't appreciate because they think they're right and that's it. But we just look and see what the case law says and how it might apply to that contract, and tell the contractor what their position is. But often, we often face claims that are rejected that should be considered to some extent. So, yeah, I'd have to read the contract to tell you what you should do with that.
I think now we've finished.
Okay.
Thank you so much, Nicholas, for giving us this final seminar in our first season. Watch, like it, and share it on YouTube. Write your comments and email us if you need anything. Well, email me if you have any further questions. And I really appreciate it you all came tonight. Let's thank Nicholas.
Thanks a lot. Thank you. Thanks.